Alright, you guys already hear the word collegium system in Indian polity. So basically collegium system is used for the appointment and the transfer of judges to the higher judiciary in India, namely as Supreme Court and the High Court. Interestingly, this system is not mentioned in our constitution, nor it was created by the act of the parliament. Instead, it is evolved over the time through the Supreme Court judgment. Now, the evolution of the collegium system evolved in a series of three judgment cases. In first judges cases in 1981, Supreme Court held that the consultation does not mean concurrence, and the president could refuse the Chief Justice's recommendation for the cogent reasons. So all over it gave primacy to the executive in judicial appointment. However, in second judge's case in 1993, the court overruled the previous verdict and interpreted consultation as concurrence. It means the consultation actually means concurrence. So this judgment established the collegium system, giving primacy to the opinion of the Chief Justice and the two senior-most judges of the Supreme Court. There are advices securing the judicial primacy upon the appointment process. And in third judge's case 1998 on presidential reference, the Supreme Court further clarify and expand the concept of the collegium. Here the court ruled that the recommendation for the appointment should not be the Chief Justice of India individual opinion, but an institutional opinion from CJI and the four senior most judges of the Supreme Court. This judgment established the current composition of the collegium system in India. So, what is the current structure of the collegium system? For the Supreme Court appointment, the collegium consists CJI and the four senior most judges of the Supreme Court. And for the High Court appointment, the collegium consists the CJI and the two senior most judges of the Supreme Court. Now moving forward, that how does the collegium actually work? For the Supreme Court appointment, the collegium send its recommendation to the government, and then the government conduct an inquiry through the intelligence bureau. It can raise objection as well, but if the collegium reinstated the same name, the government is obliged to appoint them. And for the High Court, the process is slightly different. High Court Collegium initiate the recommendation, which then passes through the state and the central government before finally reaching to the Supreme Court Collegium. The entire process is governed by the document. The document name is Memorandum of Procedure. So moving forward, why this system aim to maintain the judicial independence? It is criticized on the several grounds. The first criticism is the lack of transparency. The collegium meetings are held in secretly and no reason for the selection of the candidate and the rejection of the candidate. Second criticism is that collegium system is used to promoting the tool of nepotism. The third is the system of the judges are appoint judges that is totally undemocratic and the lack of accountability. Therefore, to address this shortcoming, in 2014, Parliament passes 99th Constitutional Amendment Act that created the NJAC, means National Judicial Appointment Commission. NJAC is a six-member body that comprises the member from both judicial and executive as well, that aim to bring transparency and balance for the appointment procedure. NJAC consists six member and the six member is CJI, two senior most judges, one law minister and two eminent person. However, in 2015, the fourth judge's case held. Supreme Court declared that the NJAC is unconstitutional. Court argued that NJAC violated the independence of the judiciary, which is the part of the basic structure of the constitution. With this judgment, the collegium system was restored and NJAC is declared null and void. Thank you.